Okay, we're going to finish up the Constitution notes. We know that we needed to have 9 of the 13 states ratified. Once we get that, and we also have to include New York and Virginia in that, because remember, once again, they were not one of the original 9. New Hampshire was the 9th, but we still needed New York and Virginia. So once those 2 states ratify, then we're able to implement this new government. So we create the first new temporary capital, and that's in New York City. So on April 30th, 1789, George Washington is inaugurated as the first President of the United States, and when you see POTUS, that's what they're talking about, President of the United States. John Adams is the first Vice President of the United States. And if you remember, one of the main arguments the Anti-Federalists used against this Constitution was that it lacked a Bill of Rights, and all or almost all of the states at that particular time had Bills of Rights attached to their constitutions. And so in order to get the Anti-Federalist support, the Federalists said the first thing we will do in this new government is to add a Bill of Rights to this. So originally there were 12 amendments that were sent to the states, and remember, if we want to change something, the states have to be part of this. So there were 12 amendments that were actually sent to the states. 10 of those were ratified, which becomes the Bill of Rights. This is important. Please get this down in your notes and please understand this. When the Bill of Rights was written, it was written at the request of the Anti-Federalists because they wanted the states to maintain power. So when the Bill of Rights were written, these protections did not apply to state governments. It only applied to the federal government. The 27th Amendment that we have today, it is the last amendment. We have 27 amendments. But interestingly enough, the 27th Amendment, which was ratified in 1992, was actually part of the original Bill of Rights. It was one of those 12 that was sent to the states. And a reminder, only 10 of them were ratified. So it was submitted to the states in 1789, but not ratified until 1992. And what the amendment says is that congressional pay raises do not go into effect until after an election. Congress gives themselves raises. They vote for them. And so what this says is, if you vote yourself a pay raise, you have to be reelected to that office to get the pay raise. And so what you'll have are people who want to take your position in the House or Senate will campaign and use that against you. They will use you and say that you have continually voted yourself a raise. So if you are not reelected, whoever is elected to that position will be the one who actually gets the raise. We have to include the 14th Amendment here. As you listen to the videos, the Amendment for Dummy videos, he will talk about the 14th Amendment throughout this, and he will talk about selective incorporation. So what that means is, on a case-by-case basis, we are going to now start to apply the Bill of Rights to the states. So it says not only can the federal government not do these things, now we're going to say that the states can. So part of the 14th Amendment was intended to secure the rights of freed slaves. It says that they have citizenship if they're born in the United States. But then we have a problem here when we're saying that we're going to give citizenship to blacks, and we're going to this idea of equal protection to the blacks. So all that did was said that applies to the federal government, that the states could continue to violate their rights. And so part of the 14th Amendment says that states can no longer deny these rights. But it didn't give a blanket statement. It basically, on a case-by-case basis, this idea of selective incorporation, every time something comes up, then we will, on a case-by-case basis, apply it. So not all of the Bill of Rights applies to the states, several of them, and we'll look at that actually in class. Amending the Constitution. We know that's Article 5 of the Constitution, and there are 2 ways to propose. That means if somebody wants to amend the Constitution, there are 2 different ways that they can do that. The only thing that I want you to know is that both of those ways have to take place at the national level, Washington, D.C. 2/3 of both houses of Congress, so we're talking about the House of Representatives and the Senate, both of them, 2/3 of their members have to vote in favor of this. But then there's a second step. We can't have the national government being allowed to change the Constitution just because they want to. Once again, just like the Declaration of Independence, just like the Constitution, everything has to be sent to the states to ratify. So there are two ways to ratify this or to formally approve this, and it takes 3/4 of all of the states. So there are two ways to propose. Both of them take place at the national level with 2/3 votes of Congress. Then there are two ways to ratify or approve it, and both of those take place at the state level, and they both deal with 3/4 of the states wanting to do this. So in essence, if you take a combination of the two ways to propose and the two ways to ratify, there are actually 4 ways in total to amend the Constitution. We haven't talked about federalism, but we have talked about the difference between a confederacy and a federal government. And we talked about in a confederacy, the states were sovereign. But in a federal government, the states and the national government share power. And so when we look at this amending process, it is a reflection of federalism because the federal government can't change it by itself, and the state government, they have to share that power. So it takes both of them, the national and the state government, to amend that. Something else you need to know is this does not involve the president. The president does not sign constitutional amendments. It's not a law, but it's a change to the Constitution. So it requires Congress, 2/3 of them, and then 3/4 of the states. You have to have a combination of both of them, but the president is not involved in this process. Thousands of amendments throughout the years have been proposed. There are amendments on equal rights and equal pay and flag burning and defining marriage as a man and a woman. There's all kinds of issues that people want to amend the Constitution to make it the law of the land. But of those thousands of amendments that have been proposed, only 33 of them have had the 2/3 support in the House and Senate that they need in order to be sent to the states. So thousands have been proposed. 33 have had the required 2/3 votes of both houses, and we're going to send those to the states. And of those 33 amendments, 27 of them have actually been ratified by 3/4 of the states, and that gives us our 27 amendments that we have today. So looking at the Constitution, we know Article 6, we talked about this in class, Article 6 of the Constitution says that the Constitution is the supreme law of the land. And we also get 6 basic principles that we have that make up, or these 6 principles are built into our Constitution. And the first one is this idea of popular sovereignty. People are sovereign. All power comes from the people. The next idea, and these aren't new, is the idea of limited government. We have rule of law. We have due process. No one is above the law, and we have written out laws, and we have a process that everyone has to follow. The next principle is the idea of checks and balances. We have a 2-step process. Each branch is responsible for their own powers, and we'll talk about separation of powers here in a second. Each one of them have their own powers, but no one branch can do thing without having a second step done by another branch of government. Congress makes the laws, but the president signs them, or he can also veto them. But then the judicial branch can go behind and rule it unconstitutional. The president appoints judges and ambassadors and cabinet members, but then the Senate gets to confirm those. The president can enter into treaties, but once again, the Senate has to confirm those treaties. So everything takes 2 steps, multiple processes. The 4th principle is separation of powers. There are 3 branches of government with specific duties. Article 1 is legislative. Make sure you know that we call that Congress here in the United States, and they are responsible for making laws. Article 2 is the executive branch. That's the president, the vice president, and the cabinet. They are responsible for enforcing laws. And then Article 3 is the judicial branch. That is the courts, and they are responsible for executing the law. The fifth principle is federalism, and this is very important, and we're going to spend a whole entire chapter on federalism, this division of power between the central and the state governments, or the national or federal government, however you want to say that. How are we going to share power? And so we're not sovereign states anymore like we were under the Articles of Confederation, but we are a federal government, and there is a specific division of those powers, and we'll look at those later. And the final principle is judicial review. Judicial review is actually not found in the Constitution, but it gives the courts the ability to determine if acts of government are constitutional or not. So they get to review, the judges or the judicial branch gets to review everything that the government does, whether it's Congress or whether it's the president. And none of them can do anything that is determined to be unconstitutional.